YouTube, it's Tone back with another one for you. And this is going to be a single video. I'm not going to have to do multiple videos of this because it's a short book. So, so the beginning part of this book is a little fucking strange because it goes over the story of how this all came to be. And, it's fucking Masonic stories of how it all came to be. And I don't even know how true it even is. But it's important to understand this part at least so that way it can bring you into now. Right? Because this is like a little bit of history and shit like that. But it brings you into today's day and age so you can understand how they were able to like sneak this whole law into what we thought that they were practicing, which is constitutional law. But this is not that. This is all fucking commercial, and I'm going to show you how. And then we're going to show you how to fucking beat it. You know what I mean? Because, I mean, you can't win if you don't know what the fuck's really going on. You know what I'm saying? And so these aren't things that you're going to find proof of and shit like that, because if you did, then whoever the fuck was part of that particular story that provided proof to the public, they would have to get fired and shit like that too. These are things that they, pretend are not happening because they operate under the guise of plausible deniability. So they're going to pretend, to the death that they have no idea what the fuck's going on because they have to. Otherwise, they're fucking admitting to guilt, and that's pretty fucking retarded. Any good criminal knows that he doesn't he doesn't tell on himself. You know what I mean? So don't fucking expect these criminals to. So here we go. So how to defeat Admiralty courts and the law of the sea, and this says sea, SEE, as in sea like visible, but it comes from a Latin word that means something else. So right here it says the Catholic word see, quote unquote CSEE, conceals the influence of the Holy Roman Church over the corrupt corporate government and legal system. The term see comes from the Latin word sedes, meaning seat, which refers to the episcopal throne, the cathedral. So the term apostolic see can refer to any see founded by one of the apostles. But when used with the definite article, it is used in the Catholic Church to refer specifically to the see of Bishop Rome, whom that church sees as a successor of St. Peter, the Prince of the Apostles. Right here, and so there's a Wikipedia link if you wanted to check that out for further elaboration. So, sedes sacrorum, right? So that's a Latin word apparently. Latin sedes for seat, SEE, sacrum for holy, otherwise known as the Santa Sede or the SS, also known in English as the Holy See. And you hear people talk about the Holy See all the time whenever they make reference to anything Catholic and shit, right? So it refers to the legal apparatus as a whole by which the Roman Catholic Pope and its curia of bishops claim historical recognition as a sovereign entity with superior legal rights. That's all the whole same concept of like, having a king and shit like that, monarchy and bullshit like that. So the Catholic Church uses two legal personalities with which to conduct its international affairs. The first is the international state known as the Vatican City State. Now, just so you know, side note, so the Vatican City is basically like what the U.S. is over here. The Vatican City is to wherever the fuck it's sitting at. So, and they're not really government. They're not even a real fucking anything. They're just basically a corporation that sits on top of the territory. And they basically occupy that, which is fucking illegal to occupy now these days. But they still do it. So, to which the Pope is the head of the government, which is crazy. You're gonna have some dude who didn't even study law be the be the fucking head of the government. Like, this is the world that we live in, guys. So the second is as the supreme legal personality above all other legal personalities by which all property and creatures are subjects. So they're saying here that everybody believes that the Pope is the supreme legal personality, and all of the creatures and subjects are subjects of his, which is crazy. So the legal enforceability of its first personal as an international state is constrained by international law. The sovereign status of the Vatican City remains dependent upon the continued recognition and agreement known as the Lateran Treaty signed between Catholics' fastest dictator and Benito Mussolini in 1929. In his political support of Pope the 11th, his recognition remains in defiance and contempt to existing international laws prohibiting recognition of rogue states and laws created by mass murdering dictators. The legal enforceability of the second personality of the Catholic Church is as the Holy See is dependent upon the continued adherence to legal statutes, definition, conventions, and covenants as have been accumulated since the Middle Ages concerning the primacy of the Pope all over the property and creatures. These statutes, conventions, and covenants remain the fabric and foundation of the modern legal system out of most states in the world. And you know that most of them are like that, actually. So hang on, I actually forgot to time the last post. So, what do we got? The covenants remain the fabric and foundation of the modern legal system of most states of the world. So they're basically saying that most of the states in the world are operating under this Catholic maritime system that we have here, which basically comes from the way that that their governments operated, using the Pope as like the president would be to the states over here and shit like that. So, to extend its legal strength using its second personality, the Catholic Church considers the region controlled by every bishop a see, which means that it's theirs, right? So, Admiralty law. Admiralty law was introduced into England by the French Queen Eleanor Aquitaine while she was acting as a regent for her son, King Richard the Lionheart. So, she had fucking crazy nickname, huh? So she had earlier established Admiralty law on the island of Oleron, which it was published as the Rules of Oleron in her own lands. Although she is often referred to in Admiralty law books as Eleanor of Guyenne, having learned about it in the Eastern Mediterranean while on crusade with her first husband, King Louis VII of France in England. Special Admiralty courts handle all Admiralty cases. These courts do not use the common law of England, but are civil law courts largely based upon the Corpus Juris Civilis of Justinian. So hang on, let me write this down. So Admiralty courts were a prominent feature in the prelude to the American Revolution. For example, the phrase in the Declaration of Independence, for depriving us in many cases of the benefits of trial by jury, refers to the practice of Parliament giving the Admiralty courts jurisdiction to enforce the Stamp Act in the American colonies. And I mean, you guys know what that whole stamp shit was about. That's when they started to tax everything. And the reason why they did that, taxing everything, was in order to bring it into their jurisdiction, because they were able to regulate commerce at that time. So because the Stamp Act was unpopular, a colonial jury was unlikely to convict the colonist of its violation. However, because Admiralty courts did not, as is true today, grant trial by jury, a colonist accused of violating the Stamp Act could be more easily convicted by the Crown. Admiralty law became part of the law of the United States as it was gradually introduced through Admiralty cases arising after adoption of the U.S. Constitution in 1789. Many American lawyers who were prominent in the American Revolution were Admiralty and maritime lawyers in their private lives. Those included are Alexander Hamilton in New York and John Adams in Massachusetts. In 1787, John Adams, who was then and I mean, side note, so if you guys ever come to Boston, you gotta visit Faneuil Hall and shit like that over there, and they always have these soldiers like dressed up like Minutemen and shit like that, doing like walkthroughs and shit like that. The shit's hilarious. You know, like the lengths that they go through to try to make these stories seem feasible or even fucking actual or true. You know what I mean? Fucking hilarious. So in 1787, John Adams, who was then ambassador to France, wrote to James Madison proposing that the U.S. Constitution, then under consideration by the states, be amended to include trial by jury in all matters of fact triable by the laws of the land as opposed to the laws of Admiralty, and not by the laws of the nations, i.e. not by the laws of Admiralty. The result was the Seventh Amendment to the U.S. Constitution. Alexander Hamilton and John Adams were both Admiralty lawyers, and Adam represented John Hancock in an Admiralty case in colonial Boston involving seizure of one of Hancock's ships for violation of customs regulations. In the more modern era, Supreme Court Justice Oliver Wendell Holmes was an Admiralty lawyer before ascending to the federal bench. And you see how it's crucial for people to understand Admiralty, right? Because then, like, that's what got him into the federal seat there. Because you got to be able to understand, common law and then contract law and things like that as well. So, Roman court is very confusing, even for some judges, because it does not operate according to any set rules of law, but rather by presumption of law. If these presumptions presented by the private bar guild bar attorneys are not rebutted, they become fact, and thereafter are said to stand as truth in commerce. Now, truth in commerce, why would they even bring up that word if it had nothing to do with commerce? You know what I'm saying? So, despite the facade, the world is a playground of commercial business and is secretly owned by private foreign corporations. And that's a fact, guys. Like, no matter how the fuck you feel about it, fact is there is no governments here, bro. This fucking... And I mean, the word government alone means mind control, okay? So, they're literally telling you what they're fucking doing to you, for one. And then they're sitting here pretending to be governments. And I mean, they're not even pretending to be governments. I mean, it's right there in your face that they're not. So, but anyway, where we at? Yeah, so I mean, fact is they're all just a bunch of private corporations parading as government officials. That's 100% facts. So, why is the Bar Guild so hell-bent on keeping everything on the private side? Because the public side invokes constitutional issues, and nothing they can do can withstand a constitutional challenge. And so, constitutional challenge / promissory estoppel is what I have for my clients as well. So it's $200 a constitutional challenge is savage, and like he said, nobody can fucking withstand a constitutional challenge if they're sitting in Admiralty courts. So the organic constitution still exists in its original glory and authority and is buried in the U.S. printing office. All amendments since 1871 do not exist. So what he's saying right here, that all the amendments since 1871 do not exist, what he's saying, well, hang on, let me finish reading this. So why? Because it was a corporate mission statement for the District of Columbia that was written in 1871 to resemble the organic constitution. So what he's saying right here is that the District of Columbia ended up writing a corporate mission statement when it became a corporation, and it just happened to be fucking exactly like the United States United States of America Constitution. And then they made their own, the U.S. Constitution, without America, United States Constitution. And but it has nothing to do with America. What it really is their corporate mission, okay? And so this is why they're able to, what do you call it? This is why they're able to go in there and change certain, characteristics of the Constitution. And they can only do, and not even just that, this is also why they can write codes and statutes that are repugnant to the Constitution, is only because what they're really doing is writing their corporate codes and statutes. That's only applicable to their employees. So technically, if you don't work for the United States as a employee, then those codes and statutes do not apply to you. They really can't. And I mean, there's no way that they even can. So it is the corporate mission statement that has been amended since 1871 and chopped up as of late. So, all they're doing is messing with their own little mission statement that happens to look like the fucking United States of America Constitution, but it's not. So, and then there's two different constitutions as well if you go look them up. So there's the Constitution for the United States of America, and there's the Constitution of the United States of America. You can go Google that. Why the fuck would there be two? You know what I'm saying? So I mean, those are the type of games that they play. It's fucking word games, which is their black magic. And so that's what they do. I know that they show you in the cartoons that black magic and witches are people out there fucking with a cauldron and a fucking pointy black hat. But these motherfuckers are black magicians, and this is how they're doing it. Fucking word games. So specifically, there is a defendant living in Florida who discovered the answer to this puzzle and properly embraced his all caps name or strawman name by registering it as a fictitious name with the state of Florida. I have templates for that too. If you guys want the fictitious name template, I have that. I mean, I don't use that personally. What I do is the UCC contracts and shit like that. But this guy did this, which kind of would serve the same purpose, but I don't think it has the same teeth as the UCC one filing. I mean, that shit's bulletproof. So this process identified him as having a commercial and intellectual proprietary interest in the all caps name. He, by entering it as such clearly on the public record, successfully rebutted all 12 presumptions on the private side of the Admiralty Court and nullified his jurisdiction. Now, what this is saying here is that, once he filed the fictitious entity, the fictitious name form with the state of Florida, the form says that he's the one that owns all intellectual rights to that particular name, which means that nobody else can use this shit. So, technically you would just have to serve that onto one of these people, and then you're gonna put them in a position to go ahead and prove a superior interest in that particular all caps entity. So what did he do? The registration of a fictitious name is something you might want to do if you wanted to open a commercial business, and if you wanted to reserve a creative name, quote unquote creative name, to identify that business. The process, however, does not obligate you to ever open a business or to incorporate. It simply reserves the name for your future use and as your commercial and intellectual proprietary property, meaning that nobody else can use it. Kind of like a trademark, if you will. Something along those lines. That's what that does. So, for many years, patriots have attempted to disassociate their sovereign beings from the legal fiction, the all caps strawman name, created by the corporate government, because this was designed to make you personally vulnerable and convert your living being into a corporation, a thing, and the property of the corporate government. So certain patriots properly decided to embrace the corporate fiction strawman as their own personal property by affidavit, using a financing statement filed under the UCC, Uniform Commercial Code, and notice of the world, and a notice to the world. This is because an unrebutted affidavit stands as truth in commerce, and the government never rebuts these affidavits. And that's because they can't rebut these affidavits. And not only that, we also put the lien onto the all caps strawman name. We create a private foreign trust, a security agreement, indemnity contracts, etc. It just goes on and on. So, and the fucking security agreements are fire. This is a service that I actually offer. So if you want your UCC 1 and 3 filed for $300, hit me up. Same day filings. So why didn't it work? The patriots bypassed one crucial step. They failed to rebut the presumptions on the private side of the corporate government and courts that imprison their sweat equity and labor. An unrebutted presumption stands as truth in commerce. Their presumption nullified the affidavit and placed them on the private side. There are 12 key presumptions asserted by the private bar guilds, which, if left unchallenged, stand as truth in commerce. And this is why it's fucking important to definitely challenge whatever it is that they're talking about. So, and you're just asking them to prove to you the cause and nature of whatever actions are being taken against your particular entity. And that's all it is. You don't really have to go there and prove anything. You just want to ask them questions. So, what do we got here? Yeah, you just want to go there and ask them questions. You want to present your facts, which would be your UCC 1 and 3 filing, and then you're going to put them in a position to have to prove superior interest in that particular entity. And then also it's going to put them in a position to answer what cause and nature that the charges are being brought under. So the public record. So the public record, public service, public oath, immunity, summons, custody, court of guardians, governments as executor beneficiary, executor de son tort, not a party to, incompetence, and guilt. So I'm only going to discuss 6 of those 12 presumptions. However, Franco Collins did a superb job addressing these presumptions in an expose titled A History of Today's Slavery, and I encourage you all to read it. So this is something out of the canons. So the canon 3228, the presumption of public record. Any matter brought before a lower Roman court is a matter of the public record, when in fact it is presumed by the private bar guild as private business, and it is a private business because they are private, corporations, but they operate in the public. So unless this, which is why they all have to be bonded and shit like that, you know what I mean? So unless this presumption is openly rebutted by filing or stating clearly on the public record that the matter is to be part of the public record, the matter remains on the private side as private bar guild business under private bar guild rules, right? And so this is why they're able to just fucking stomp all over you in court, is because you're going in there arguing their copywritten codes and statutes as if you know them better than them. And I mean, fucking I do, to be honest with you. I could beat them even with their own fucking codes and statutes. These dudes really don't have that power. They just hide it in fucking codes and statutes. You know what I'm saying? So so they're not even good with that, for one, and then they take it a step further and then just do whatever the fuck that they want. You know what I'm saying? Motherfuckers are retarded. So all right, so the defendant in this particular case recorded on the public record that the registration certificate issued by the state of Florida identifying his registered ownership of the fictitious all caps name, which proved that he was not the alleged defendant on the court's docket. I believe I should refer to him as the alleged defendant from here on. So another canon, 3228, the presumptions of public service, oath, and immunity. If the judge ignores the alleged defendant's fictitious name registration entered into the public record, which is clearly presented to him in open court, and then decides to move forward with the case, he violates his public service oath and judicial immunity under these subsections. So basically what that's saying is that if he decides to move forward, he's not only knowingly committing a felony, but he's no longer under the immunity that he would have had he stuck to the oath that he fucking signed. Yeah, the oath that he signed. Right? So, another canon, 3228, 5, the presumption of summons. A summons was, when unrebutted, stands as truth in commerce. Attendance in a court is usually invoked by invitation, and therefore one who attends court initiated by a summons or warrant, subpoena, or replevin bond is presumed to accept the position of defendant, juror, witness, or thing and the jurisdiction of the court. And that's a fact too, right? So you definitely want to ask them to fucking talk about the summons that they sent you, right? And if they even served you properly. You know, it's supposed to be sent out by fucking certified mail and hand delivered and all that shit. These motherfuckers don't do any of that. They just send it in the mail, and fucking a few days later they just go ahead and throw a fucking warrant out and shit. These motherfuckers are ridiculous. So if these statements are not rejected and returned with a copy of the rejection filed clearly on the public record jurisdiction, then presumed position and the presumption of guilt also stands as truth in commerce as well. So basically what they're saying is that if you don't send it back rejected, then you're fucking admitting to guilt and all that shit too. So in this particular case, the alleged defendant rebutted his forced appearance by presenting the judge with the recorded registration certificate issued by Florida. This certificate stated that he is not the defendant on the court's docket. The name is fictitious, and I am the registered owner of that under Florida law. So Canon 3228, 6, the presumption of custody. So those who attend a court initiated pursuant to the command of a summons or warrant is presumed to be the corporate property or a thing, and therefore is liable to be detained in custody by the court's appointed or elected custodian. Custodians may only retain custody over property and things, and not flesh and blood living beings, unless this presumption is openly challenged by rejection of the summons or warrant on the public record. The presumption stands as truth in commerce, and you are thereafter treated as a thing or property. In this particular case, this presumption was absolutely rebutted when the alleged defendant proved his arrest was a case of mistaken identity, and in no way could the court custodian detain him after that. I do not accept this offer to contract, and I do not consent to these proceedings. And you got to be clear when you're fucking talking to these people. And don't just go doing this shit because you seen this fucking video and you like grew some balls out of the blue. Don't go getting yourself fucking locked up. Definitely get your contracts in place before you start acting like a dick. So in addition to the above sections of canon law 3228, the defendant has also unknowingly rebutted the balance of the 12 presumptions. So there it is. Right? So what this dude's talking about... Hang on a second, I just lost this. Yeah, so what this dude's talking about here... What this dude's talking about here is if you take these few actions that were just mentioned above, right? The fictitious name, certification, you get your UCC and all that shit done. You know, then you can come in there and you can play ball because you have something to fucking talk about. Otherwise, you're going in there using their codes and statutes and think you're somehow gonna get over on them using their copywritten material. You're out of your fucking mind. That's a lawyer's job. So court guardians, court trustees, governments as executor and beneficiary. So the incompetence, guilt. This particular defendant succeeded in accomplishing all of this by registering his all caps name as a fictitious name, in which only he now owns an absolute commercial and intellectual proprietary interest in the state of Florida. By entering it into the public record, he has overcome all 12 presumptions and nullified the prosecution and jurisdiction of the private Roman court. His next step would be to record it in the UCC, which is a notice to the world. And that's what the UCC is. Now, keep in mind that when you file your UCC, it's not that just fucking everybody knows. You have to notify certain entities that you're going to be coming in contact with. And even if you end up in a jam after that or fucking before that and file your UCC after you got a case going or whatever, it's definitely still valid at that point, but you're going to have to notice everybody separately. It ain't that because you go file your UCC that the judge is going to find out tomorrow and shit. You're going to have to fucking actually have them served with that. So, checkmate. There is no way for the corporate government and private Roman court to proceed against this living being. If the prosecutor was to disclose these presumptuous frauds that the court had been operating under on the private side, it would also nullify the case and subject the judge to arrest and damages for prosecutorial fraud and the absence of jurisdiction. So please note that the judge's only legal response to the alleged defendant is to order a stay until the defendant secures counsel, meaning an attorney and bar guild member. If it is reported that the alleged defendant has not secured counsel, the case remains absolutely deadlocked. If this open stay does not cause him any harm, and it shouldn't, then he can choose to either do nothing, he can file a 2-page motion to dismiss, or he can file a rule to show cause seeking a summary judgment for damages on behalf of his living being. What would happen if the individual follows the judge's advice and hires an attorney? In all probability, his attorney would use the alleged defendant's signed power of attorney to withdraw the fictitious name registration from the public record. The defendant would more than likely be imprisoned and tried on the private side and convicted. So that's not what you want to do. You know what I mean? And even when you go get a lawyer, all they fucking do is argue. And when you, when you start arguing with these people, you're, what do you call it? When you start arguing with these people, you're causing controversy. And the only way that you can really end up in court in front of a judge, which is just a fucking referee, the only way you're going to end up in front of one of those people is if there's controversy involved. And you know that there is none because these people don't have any jurisdiction. If you raise controversy, you're breathing life into their fucking nonsense. You know what I'm saying? So that's not a good move. So what other applications can this process be used for? Licensing, tax collections, foreclosures, debt collections, the vehicle code, to name a few. Again, checkmate. Don't you just love a good story with a happy ending? From shiftfrequency.com. So, what am I looking at? All right, so right here. So, Black's Compendium on Maritime Admiralty Law Word Book. So, you guys definitely gotta Definitely got to study maritime law. Ultimately, being this is that everything's commercial. Everything is about contracts. So if you don't have a contract in place, you have nothing to fucking talk about. You're gonna go in there and their presumption is gonna win because not only are they fucking presuming and assuming all this jurisdiction bullshit whenever they drag you into court, everybody in the courtroom is fucking brainwashed too. So they're all gonna be looking at you like you're the fucking crazy one, when none of these motherfuckers, I can guarantee you, have ever opened a fucking law book. You know what I'm saying? And if they did, they didn't fucking read it. You know what I'm saying? So like that's who you're dealing with. So get your contracts in place. UCC 1 and 3 filing service, $300. Hit me up. Sovereign Productions 369 at gmail.com. It is a game of chess. Stop playing checkers with these clowns. That's what I got for you. Until we meet again.